This is an essay on discretion. In the field of policing, police are allowed to make a lot of discretionary decisions to a certain extent. Discretion plays a key role in how a police officer operates. The term discretion means the power and ability to make decisions. Police discretion is vaguely defined and is governed by state statutes and department policies. Some decisions are easier than others, and there are some more complex. The most difficult discretionary decisions police have to make is whether to use deadly force. Deadly force is a use of force that is likely to cause serious injury or death to another person. In most jurisdictions, the use of deadly force is justified by under conditions of extreme necessity as a last resort when all lesser means have failed. Minnesota is one of the states that gives significant amount of discretion to officers when it comes to using deadly force. In fact, Minnesota, only one officer has ever been convicted for killing someone while on duty. Minnesota State Statute 609066 defines deadly force as a force which the actor uses for the purpose of causing or which the actor should reasonably know creates substantial risk of causing death or great bodily harm to protect the peace officer or another from apparent death or great bodily harm. The statute gives three situations when officers can use discretion involving deadly force. The first situation is when arresting or preventing the escape of a person for whom the officer knows or believes has committed a felony involving use of deadly force. The second situation is when arresting or preventing the escape of a person whom the officer knows has committed a felony. The officer reasonably believes that person would cause death or great bodily harm. Third situation is the officer protecting himself or another from bodily harm or death. There have been several examples in Minnesota where officers have acquitted or charges have been dropped against them due to protection from Minnesota state law. An example of police using discretion in deadly force situation was the Philando Castle shooting in July 2016 during a traffic stop at St. Anthony. Officer named Geronimo Yanez shot and killed Philando Castle. However, Yanez was acquitted on all charges. Jurors in that case pointed to the law authorizing police to use deadly force to explain their decision to find Yanez not guilty. The officer in this case used discretionary decision to use deadly force in order to prevent bodily harm or to himself or another officer. Another example is on June 23rd, 2018, when an individual named Thurman Blevins was shot and killed by police. Mike Freeman, a Hennepin County attorney, announced that he would not charge the officers involved. Freeman cited state law, which he said provides significant defense to criminal charges against an officer. Minnesota falls in line with many other states that offer similar discretion for officers in cases where use deadly force. However, doesn't stop people from voicing their opinions about the law. After the death of Flannel Castle, protesters took to the streets to express their frustrations with laws governing deadly force. Some protested peacefully and showed their solidarity, while some are more demonstrative and clashed with police. This shows that people are looking for some sort of accountability, that they are trying to send a message to state lawmakers to change how police use deadly force. Regardless of how people view the law, the state of Minnesota, along with their state, to write laws containing discretion to use deadly force into language, but they realize that police have a difficult job that requires them to make split-second decisions, making they must be able to have a significant amount of discretion when performing their duties. This is the discretion essay.